Welcome to the Race in Britain podcast. I'm your host, Ishan Khurana. In this episode, we're going to be talking about race, immigration and the future of work with Dr. Nadine El-Anani and Dalia Gabriel. This episode was recorded as part of an event hosted by Autonomy, a think tank producing research on the future of work. Nadine is a senior lecturer in law at Birkbeck School of Law and co-director of the Centre for Research on Race and Law. Dalia is an ESRC-funded PhD candidate at the London School of Economics, working on race and gender in the platform economy. The event begins with a talk on some of the central points made in Nadine's book, Bordering Britain, which was published in February 2020 by Manchester University Press. We then move on to a conversation between Nadine and Dalia about race, immigration status, and work. The discussion places immigration law within a colonial context. It analyses how racialising legal categories have emerged over time within British immigration law and offers empowering articulations against the violence of borders. So without further ado, let's hear from Nadine El-Anani.
Immigration law in particular teaches white British citizens that Britain and everything within it is rightfully theirs. Others are here as guests. I challenge law's lesson that some people are entitled to space, resources, and opportunities, and others are not, by showing how British immigration and nationality law is an extension of British colonialism. I argue that Britain's borders, articulated and policed via immigration laws, maintain the global racial order established by colonialism, whereby colonized peoples are dispossessed of land and resources. They also maintain Britain as a racially and colonially configured space in which the racialized poor are subject to the operation of internal borders and are disproportionately vulnerable to street and state racial terror. Britain is thus not only bordered, but also racially and colonially ordered through the operation of immigration control. Of course, Britain would not be the wealthy, plentiful place that it is without its colonial history. Colonialism and slavery were key to its industrialization and the growth of its capitalist economy. In 1833, Britain abolished slavery only to raise the equivalent of £17 billion in compensation to be paid to British slave owners for the loss of their property. The compensation scheme was the largest state-sponsored payout in British history until it was superseded by the bank bailouts of 2008. The funds paid out built and infused Britain's commercial, cultural, imperial, and political institutions. Wealth derived from British slave ownership has by no means been evenly distributed in Britain. It has helped to enrich and sustain elite institutions, individuals, and families, and has sown inequality deep into the fabric of British society, helping to make it the most unequal place in Europe. Yet Britain's healthcare system, welfare state, transportation infrastructure, cultural and educational institutions, battered and unequally accessible as they are in the wake of privatization and austerity policies, are colonially derived, along with the private wealth amassed over the course of the British Empire and retained after its defeat via systems of inheritance. The 1960s, 70s, and 80s are particularly important decades in the story of immigration law and the making of modern Britain. As colonial populations fought the British from their territories, British lawmakers fast abandoned the myth of imperial unity and equality and moved to introduce controls targeted at racialized colonial subjects and Commonwealth citizens. This legislation culminated in the 1981 British Nationality Act, which raised for the first time the spectre of a post-imperial, territorially defined and circumscribed Britain. It severed a notionally white, geographically distinct Britain from the remainder of its colonies and Commonwealth. Through the concept of patriality, the 1971 Immigration Act had made whiteness intrinsic to British identity. Only patrials, those born in Britain or with a parent born in Britain, had a right of abode and therefore a right of entry and stay in Britain. In 1971, a person born in Britain was 98% likely to be white. The 1981 Act continued this process of racial exclusion by constructing British citizenship on the foundation of the 1971 Act's concept of patriality, tying citizenship to the right of entry and abode. The move was both materially and symbolically significant. A territorially distinct Britain and a concept of citizenship that made Britishness commensurate with whiteness made it clear that Britain, the landmass and everything within it, belongs to Britons conceived intrinsically as white. The 1981 Act did not therefore signify an end to British colonialism, but was itself a colonial manoeuvre. It was an act of appropriation, a final seizure of the wealth and infrastructure secured through centuries of colonial conquest. In the book, I argue that understanding Britain as a contemporary colonial space in this way serves to partially collapse the distinction between settler and non-settler colonial contexts. While it is now an accepted argument in critical scholarship that settler colonialism is ongoing and structural, the same critique has not been applied to non-settler forms of colonialism, which are considered to have ended. Yet the border around the spoils of British colonial conquest via immigration and nationality law amounts to an unredressed act of colonial theft. Due to mainstream understandings of property as being fixed and immovable in space and time, theft by the passing of immigration controls can be difficult to conceptualize. Along with the resources and labor stolen in the course of colonialism, the social and cultural networks and relationships that were annihilated or radically reformulated as a result of colonial conquest were also material losses. Colonial dispossession not only determined the contemporary distribution of material wealth, but also radically altered subjectivity in the sense of what people desire, consider themselves as entitled to, and understand themselves to be. Theft of intangibles such as economic growth and prospects, opportunities, life chances, psyches, and futures occur in all colonial contexts, settler or otherwise. The effect of the 1981 Act, along with changes to immigration law, was therefore to put the wealth of Britain gained via colonial conquest out of reach for the vast majority of people racialized through colonial processes, most of whom with geographical or ancestral histories of British colonialism. Immigration law not only serves as the means of obstruction of movement, it is also the means through which legal status is granted. While critiques of recognition are well established in settler colonial studies, the same critique has not been made in relation to Britain. Regimes of legal status recognition, whereby British authorities determine entitlement to statuses such as citizenship, settlement, or indefinite leave to remain, or refugee status, serve to legitimize the claim that colonial wealth, as it manifests in Britain, belongs behind its borders only to be accessed with permission. Similar to the way in which Indigenous people in Canada and Australia must submit to the rules and evidentiary standards of those colonial legal systems in order to be recognized as having enforceable rights to land, those with ancestral, geographical, and personal histories of British colonialism who wish to access colonial spoils in Britain must submit to the rules and evidentiary standards of British immigration law. In this way, a facade of racial inclusion has been built in the form of paths to legal status recognition, which dole out immigration statuses to select racialized people who can fulfill certain criteria. Such recognition is always on the terms of the colonial state. Meanwhile, the vast majority of racialized people are prevented from accessing Britain and its wealth, gained in part through the operation of internal and external borders produced and enforced through law. The bestowal or extension of British subjecthood or citizenship in its current guise can thus never be anything other than a colonial act. In the colonial era, British subjecthood was held up as a superior category from which the civilizing benefits of British rule flowed. Yet British colonialism was genocide, mass murder, slavery, dispossession of land, exploitation of labor, and theft of resources, all predicated on white British supremacy. Even so-called free British subjects seeking to move to different parts of the British Empire were met with racist immigration laws in places such as Canada and Australia, which heavily influenced Britain's first immigration law passed in 1905. British subjecthood did not therefore protect racialized subjects from the violence of white British supremacy. Its very existence as a legal category was a manifestation of that violence. Whenever it has suited the British government, it has treated its subjects as aliens for legal purposes, evicting them from the scope of legal status and protection with devastating consequences. The effect of the hostile environment policy, for instance, was to deny many of the Windrush generation and their children access to healthcare, housing, employment, and other vital services, and to detain and expel them. The traditional acceptance of legal categories as defined in international and domestic law in and outside academia has the effect of concealing law's role in producing racialized subjects and racial violence. It further impedes an understanding of law as racial violence. Take, for example, the category of the refugee, relatively valorized as compared with the irregularized migrant. Individuals falling outside the legal definition of a refugee are often described as illegal, irregular, or economic migrants, and are at risk of removal and denied access to healthcare, housing, and work. A decision to deny legal status carries serious, sometimes fatal consequences, and can be a politically expedient move on the part of a government seeking to apportion degrees of belonging, entitlement, and exclusion among populations under its control. Addressing the historical contingency and artificiality of legal categories, the violence in their production, and ongoing material effects allows us to understand how Britain remains colonially and racially configured. It also helps to mitigate against a liberal politics of recognition and opens the way for the development of emancipatory and reparative discourses and strategies for migrant and solidarity and racial justice. Legal status does not alter the way in which racialized people are cast in white spaces as undeserving guests, outsiders, or intruders, as here today, but always potentially gone tomorrow. Immigration law is the prop that is used to teach white British citizens that what Britain plundered from its colonies is theirs and theirs alone. Immigration law is not therefore the seemingly harsh but fair mode through which the deserving are separated from the undeserving. Instead, it is a crucial mechanism for ensuring that the colonial wealth that was stolen remains out of the hands of those from whom it was taken. Understanding that immigration law is an extension of colonialism enables us to question Britain's claim to being a legitimately bordered sovereign nation state. If we, as critical scholars and activists, can imbibe a counter-pedagogy to that of immigration law and bordering, one which rejects the violence of legal categorization and paves the way for a more empowering, redistributive, and radical politics of racial justice, we can begin to work our way towards new strategies for organizing collectively in the service of anti-racism and migrant solidarity. With this in mind, we shouldn't wait for the law to rule on our entitlement to colonial spoils. A Britain understood as the spoils of empire already belongs to us. Thank you.
Okay, thanks so much for that, Nadine. I felt the book has really helped me articulate some of the demands around our right to remain. And I think particularly because the stuff that you've written has resonated both with my story of coming here, but also as I think as same with the way you arrived here or your parents arrived here. So I'm going to hand over to Dahlia now to guide us through the next part of the discussion. So please keep sending questions in if you have any.
Thank you so much, Nadine, for that. It was, I'd really recommend this book. I think it's really, really critical for anyone who wants to understand how Britain has come to exist in the way it exists now. And thank you again, also Autonomy, for for putting on this event and getting us to start talking about the relationship between immigration and immigrant rights and the anti-racist fight, and the different struggles around work as well. This is sort of something that is very very sort of close to my heart. So what Nadine's book is really, really good at doing is it's kind of it outlines how, in the particular context of Britain and Britain's history, how immigration law has always been a key part of how race has operated as a system of basically categorizing and hierarchizing human life. And it's through those categories that are created by racialization, of which immigration law is such a key part, particularly in the British context, because of the context of the empire. Those categories that are created by racialization is how basically are the categories through which the access to the means of life, to the means of survival, is sort of distributed and managed. And other example, immigration law is one facet of this, but there is something about the kind of, particularly when Nadine talks about the liberal politics of recognition and how this kind of idea of being kind of like pro-migrant within the boundaries of these legal categories. So we saw this very much with the Remain campaign, with that kind of pushing of the Remain campaign as being the main articulation of migrants' rights that was allowed on kind of mainstream platforms, how that kind of very much operates within this idea of those legal categories of when, you know, when something becomes law, it basically becomes something that you can't resist without committing a crime, and therefore without being subject to any amount of state violence that is necessary in order to enforce those categories. So obviously we've seen what's happened in the US, but these very tactics of kind of claiming violent resistance from people who are being subject to state violence, and then using that as an excuse to murder people in very graphic and very sort of brutal ways. I was reminded every time I'm trying to avoid videos of George Floyd, but every time I see it, I'm reminded of Jimmy Mubenga, of Joy Gardner, and the particular ways in which they were also killed by the state. So when we think about the relationship between law, race, and work, it's really in the history of how the category of race has kind of come to exist with the potency that it does. So we can't pinpoint the beginning of race as a system, obviously. It's not traceable to like a single moment, but to sort of lots of moments that have become consolidated and continue to have life breathed into them. But if we look at one example, so the creation of the category of Negro and white in US law, this was a moment that explicitly kind of like lays bare the connections between work, law, and race. So the establishment of the legal category of Negro in US law is critical in the establishment of the transatlantic slave trade, and therefore is critical in the establishment of capitalism itself. So these categories basically became encoded in law 60 years after Africans first arrived on the plantations of Virginia in 1619. And the creation of these categories of sort of the white and the Negro was a response to the collective and armed uprising of English and African indentured laborers who had previously been working alongside each other. So in creating these legal categories of white and Negro, what we're seeing is two categories of worker emerge. The white laborer, who is exploited but paid, and has the capacity to kind of have some mobility, and the slave. So as Satnam Virdi writes, and I would really recommend the work of Satnam Virdi, particularly his work on racial capitalism. If these developments had just happened in Virginia, that would be one thing. But what's significant here is that these social processes and mechanisms that help birth racism in Virginia were reproduced across colonial English America, the Caribbean, South Asia, and Africa, and then through the slave trade, through empire. This goes from being a confined moment to a moment that continues to underpin the logic of how we live today. So we can see in that moment how work, race, and class composition and the law are historically enmeshed. And Nadine's book really brilliantly lays out how these kinds of logics function in Britain today. So when you look at the kind of legal matrices of Windrush, the hostile environment, what we're seeing is the creation of new categories and the reinforcement of old categories of people through the immigration system along the lines of class, race, nationality, disability, and religion. And that's tied to work in two ways. So it manages who has the ability to access work and therefore the means of life, but it also manages what kind of work the people who fall at the bottom of the law's hierarchy are pushed into. So what I mean by the first bit is fairly clear. So as Nadine points out in her book, people who fall on the wrong side of legal boundaries around migration, i.e. people of color, particularly poor people of color, they are illegal or they are irregular, and they are denied access to work and therefore housing and healthcare, etc. And this is actually where the left can become very complicit in the technologies of state racism, because this idea that the state should preserve formalized and unionized and well-paid jobs for native populations, and crack down on businesses that hire undocumented or irregular migrants, is something that we've actually heard from British trade unions from as far back as the Jewish migrations into Britain in the late 18th century. The second point is that, of course, people still have to work to survive, even if they come in an undocumented, even if they come as undocumented people and are not legally entitled to work. So a study by the Migration Observatory showed that increasing immigration controls doesn't actually reduce the number of people who move to Britain, because people will, as we know, will undergo all kinds of treacherous and scary and horrible conditions in order to access this, as Nadine talked about it, the spoils of empire to which they are entitled. But what it does do, sort of increasing immigration law, what it does do is increase the proportion of the people who move to Britain being legally categorized as undocumented or irregular. So it creates this pool of people who have been classified in ways that make them incredibly precarious. And so this is where we see people entering informal economies of work, economies that keep our urbanized world running, but are sites of extreme abuse and exploitation. So the irregular migrant becomes the irregular worker. So on the face of it, it seems contradictory that the state is so anti-migrant, yet knows that it needs migrants in order to exist as an urban center. But when you go back to that Migration Observatory report, you can see that it's not a contradiction. There is nothing inherent about migrants that make them hardworking or more willing to accept bad working conditions. They have to be produced in a way that leaves them no other choice. And that's where the legal boundary making comes in. So my work is, and I'm going to speak about this really briefly, but my work is on platform economies, also known as kind of gig economies, particularly ones that are mediated through digital platforms. And a big sort of part of, the literature talks a lot about how the misclassification of platform workers as independent contractors is a key way that platforms exploit people. So classifying workers as independent contractors, basically, the short of it is it deprives them of workers' rights. So it deprives them of the means of life through healthcare, through compensation, through a pension, through maternity leave, through sick leave. And there is often, the literature will kind of very flippantly talk about how a lot of the platform workforce across the world, in global cities across the world, but also in big cities, so not just global cities, they will say, oh, a lot of the people doing this work tend to be migrants, and they'll kind of swoop over that. But what we're looking at here is the intersection of creating new categories of worker in ways that deprive them of fundamental rights, and the continued creation and reinforcement of old categories of migrants that also deprive them of fundamental rights. And these two things are working together to create the platform economy. So there is something very intrinsically related between how those two shifts are working. And through both of those categories, we are seeing access to the means of life being withheld and managed. And those access to means of life mean material things, so economic resources, shelter, safety, healthcare. They also mean the ability to have community, to have forms of kinship, to have family ties, to have a sense of rootedness. So for me, what I'm really interested in here, and what I think Nadine's book is really critical for, is talking about how immigration law is central to class composition. And oftentimes the right is trying to create a culture war between the white working class and the metropolitan elite, who get lumped in with migrants, as if somehow migrants and the metropolitan elite are in cahoots with each other to screw over the white working class. And that creation of a culture war goes all the way, has its roots in that moment in Virginia, when the legal categories of white and Negro were created in order to break solidarity between workers that had previously been working together. So so I guess that's kind of me trying to kind of bring this into questions of the future of work and the question of digital economies. And I guess I would be really interested to hear from you, Nadine, whether you have sort of seen histories of what kinds of work migrants are pushed into and the role that work has in the functioning of our cities, but also that seeming contradiction between the sort of hatred of migrants by the state, but also the necessity of them. their expendability but their necessity coexisting in what is quite a fractious relationship, I think.
Thank you so much, Dalia, for your thoughts and for, I think, really relating the book to your own work in such a fascinating way. And it certainly makes me want to know more about, read more about your work. And I think what struck me as very strongly is the way in which we're both very interested in categorization and the violence that is done through categorization. And of course, categorization as a process and a technique is central to law. It's all about sorting individuals or even creating categories of people, or producing categories in order to then allocate, as you were talking about it, access to means of life. I talk about it in similar terms, but access to colonial spoils, which I conceptualize very broadly as not just what we find in the British Museum, but really everything that some people, we are lucky enough to take for granted, ranging from shelter to work, employment, opportunities, or just the sense of having a freedom to choose what one wants to do with one's life. And I was really struck by what you said about forming community, because that's the other thing that the law very violently takes away from racialized people is community, is family, the choice to make a family. And I discuss in the book at length case law, which around human rights law, which is of course about protecting people's right to a private family life. If we take Article 8 of the ECHR, for example, but of course interference with that right is permitted under certain circumstances. And what you find tragically is it's migrants, particularly irregularized migrants, or migrants who have been convicted of a criminal offense, who are deprived the opportunity to form family links and bonds and believe that they will be protected and be trusted. And actually what we find in the Rupaya judgment is that the court goes even further to say that you are a precarious, you're precarious, your status is precarious, and therefore unlikely to be protected if it comes to your risk of being removed, and then you're seeking to rely on Article 8, if you have anything other than indefinite leave to remain. And yet we know the reality of the situation is even worse, because of course even people with citizenship who are racialized are more likely to have their citizenship deprived. And of course, we can get lost in talk about the status and legal categories and the terms of human rights legislation. But what we're actually talking about is what you were saying, Dalia, is the deprivation of basic ability to live out one's life in the way one chooses. To have things that people take for granted. And all of this, I think, are important to, all of these things we take for granted, I think, are important to conceptualize as property, as material things that have been stolen. And so I was really struck by you taking us back to the legal distinction between the Negro and the white, and the creation of the Negro as property, because of course it is exactly conceptualizations of property and our inability to really understand them today as anything other than physical land or something immovable. That means that we don't really broaden our fights for justice or our arguments around what people should be entitled to anything other than what the law says people are entitled to. And that's precisely the danger that I'm trying to point out, that we need to be very vigilant around law, is that it appears to have fallen from the sky and to fairly and in the spirit of justice organize life, but it really does quite the opposite. Modes of categorization and techniques of categorization go back to the colonial period, when categorization was a means of organizing life, humans, individuals, into non-humans and humans, into people that could be treated as property. And we see that those very same assumptions and patterns are still very much embodied in law today. And I think you gave some great examples about the way in which old and new categories, whether they're old or whether they're new, they produce the very same result, which is making racialized people, poor racialized people, vulnerable to harm and premature death, if you want to use Ruth Wilson Gilmore's sort of notion of of racism. And so I think it is about being very vigilant when we think about the law, and being careful in the kind of arguments we make. So I think you mentioned briefly Windrush, or the sorts of arguments we see amongst activists, for instance, around Windrush, saying, well, you know, these are not only good and law-abiding citizens, but they're also have a right. They were British citizens when they arrived. And I think, and the risk, of course, is that you're that by making that argument, you're buying in to the category of British subjecthood, to the very vehicle of colonial violence, and the very divide and rule sort of tactics, the very divisive tactics of categorization that you were talking about, that means that we can say one group of migrants is good and law-abiding and imbued with rights, and therefore can remain, and the other group has somehow not met the category. So, for example, has not met the criteria for citizenship or naturalization. So, for instance, is deemed to be not of good character and therefore cannot naturalize. Which, of course, itself as a process embodies the very civilizational logic of colonialism, to say you are of good character, you are civilized, you, however, are a barbarian and cannot be taken into the folds of a British way of life. And so so sort of invoking legal categories in this way, so much damage is done to the core of what would be an actual politics of solidarity, migrant solidarity. So yeah, I think I'll just end on that, and I don't know, Dalia, if you want to come back on that, or whether we're opening for questions now. I'll leave it to Ishan to decide.
I think you guys can discuss for a bit longer.
Yeah, I mean, I think that's all really, really critical. And I also, when you talk about how a lot of the discourse around Windrush, it sort of bought into this idea of British subjecthood. What it also buys into is this idea that those who fall outside of that privileged category of British subjecthood can be left to die. And I think that notion of with George Floyd and the kind of uprisings around police brutality, rightly we focus a lot on sort of when the state kind of murders in quite an explicit way, but there's also an everyday kind of slow violence of people who are left to die because they fall through these cracks, or they are left to be exposed to violence. And Gargi Bhattacharya talks really well, writes very well about this idea of the neglectful state and the withdrawal of the state from all of its practices except for the punitive ones. So it's withdrawing from, ideas of provision of housing and coordination of healthcare, as we've seen. The state seems unable to distribute masks, but is totally able to distribute, highly militarized soldiers essentially on their streets, in order to fight racialized people on the streets. So again, this idea of where the state is putting its resources, but also how being falling through those cracks of those categories, both when it comes to, and that is also what the platform economy's model relies on, is it relies on these kind of loopholes that allow what particular workers who are trapped into particular, who are not covered by sort of like the category of worker. They are not considered a worker and therefore do not have access to the gains that the workers' movement has made. The workers' movement also being being very much powered by migrants as well across the world. So I think that idea as well of how and it really came actually to me as well with the kind of coronavirus response. So Rishi Sunak was really applauded for his massive sort of coronavirus rescue package, but the fact that the coronavirus rescue package by default only applied to people who get to be in that privileged category of worker, and that it ignored all those people, largely platform workers, largely migrants, who fall through the cracks because they are not considered a worker, even though they very much are workers, and therefore do not have access to the modes of relief that are provided when the state does rarely choose to intervene in ways that are not punitive. And you kind of, there was something that I was Yeah, so and then when we kind of talk about that, we see that a lot of the sectors where people are losing the status of worker are the sectors that have been historically dominated by migrants, and are the sectors that are often infrastructural sectors. So the delivery drivers, the couriers, the care workers, the domestic workers. And I don't think it's not a coincidence that these are the forms of work that are becoming platformized. There's lots of different, it's very much easier to automate an accountant, but there's a reason why accountancy workers are being protected from that. And it's because their ability to sit within that category of worker and therefore access particular workers' rights, albeit diminishing, is a lot more fixed. So yeah, and I think what I've been thinking as well about what should our political calls be in response to, so we've outlined the taxonomy of how this works. We've outlined how the government not only uses categories, but also uses incredibly complex bureaucratic matrices that workers who are already overstretched, who are already precarious, for work, when Rishi Sunak eventually did get his coronavirus package for self-employed workers and platform workers through, it involved these layers of paperwork and bureaucracy that is very difficult to access for people who are already overstretched, who may have language barriers, just completely out of touch with the reality of people's lives. So I kind of wondered, well, what is the opposition? How do we oppose this? And for me, I've been increasingly just coming back to this idea of universality. And I think our movements have often lost this idea of universality. I think for many good reasons, we've had to fight for the pluralism of, how people's lives manifest in lots of different ways. And in many ways, it feels like our movements are constantly splitting into more and more groups. But I think that that's important. It's important to have that kind of localized, special, and that specific analysis. But I think we really need to begin to be brought back into this idea of the universal, of this idea that people have a right, people have universal rights, and that our calls need to be universal and not cordoned off, not allow these kind of bureaucratic machines that split us off into all these different kinds of categories to win the day. And I think that that's sort of the terms in which we should be thinking. And sometimes universalism can be hard to defend. Sometimes it's thorny, and sometimes it's difficult and it's sticky. But it is the only weapon that we have, really, against this system that is constantly trying to tell us that we are better or we are so different to people who live next door to us, as a way of enforcing that distribution of resources and rights through these mechanisms. And this is going to become increasingly important as crises, economic crises, climate crises, health crises, increasingly create this idea of scarcity. As these ideas of scarcity become more and more prevalent and grip the populace more, which is going to be particularly a problem when we come to the climate, when we come to the way that climate breakdown is going to continue to get worse. When we have those ideas of scarcity, that's when the category of who gets access to the means of life becomes smaller and smaller and smaller and smaller. So yeah, I think looking and for me, I think a lot of, in my line of work, that's really looking at how the categories of citizen and worker are beginning to overlap. And I think as socialists, as communists, or whoever, we whatever, we need to start looking at what do we do when the basis of our analysis is workers' rights, but not everyone gets to be called a worker, even if they are doing that work. And same with citizen, as those categories are increasingly becoming very co-constitutive.
Thanks, Dalia. Yeah, so there's a lot there. I really, you started out by talking about the idea of who is the person or group of people who are left out of categories, and what happens to them as a result. And you talked about them being left to die, and then you mentioned, of course, the very useful way of understanding violence, not only as the sort of imminent, brutal violence that we see in relation to the way in which Black people are killed in custody, as is being brought to the fore very vociferously right now, but also occurs through a kind of slow violence. And I've written about slow violence in relation to, for instance, the Grenfell Tower fire. And of course, there the idea of the neglectful state is very important. And I think that leads nicely onto the question of political calls and the demands that we're making. Because of course, if you think about Grenfell, I think that one of the reasons we have not seen a reaction to what happened at Grenfell when 72 lives, the vast majority racialized as Muslim in particular, lives were lost. We did not see a public outcry in the way that we might have seen, I would argue, had the people who died really been seen as human. Had they been white, I think that we would have seen a very different response to Grenfell than we are seeing now. And I think it's important to note that also in relation to COVID-19 and the way in which we see racialized people are dying in disproportionate numbers, of course, because they find themselves in locations, in areas of work, in living spaces that make them more vulnerable to infection and death. And so we're seeing the ongoing pattern that we've discussed in relation also to migration. Who are those who die at sea? Who are those who don't have the right to a visa? Who are those who cannot take an aeroplane to travel and who must take dangerous journeys and therefore find themselves more likely to die as a result? So and I think what this leads me on to is when we're thinking about political calls, it's important to diagnose what's happening. And I think you said, oh, we have diagnosed what's happening, and we've established the taxonomy, and now it's about where we're moving from here. And I think, and I agree with everything that you said in its spirit, but I think that the thing I would take issue with is this idea of the universal. Because if we think about the idea of the universal, and the notion of universal rights, that everybody should, regardless of who they are, have rights. Of course, it's a wonderful idea in practice, but unfortunately, it's the very core of the way in which law operates. It is exactly to say, of course, everybody has these rights. These are human rights. The problem is that some people are not conceptualized as human. They're not understood as human, and therefore they are not treated as human, and they fall outside of those categories. So I suppose, I think what you're talking about is solidarity. You know, perhaps when you talk about universal or a universal struggle, we're talking about solidarity across the kinds of differences or divisiveness that is imposed on our ways of life and being constantly through law and categorizations of worker as well, and who falls in and outside. But I think that we have to first grapple with this idea that unless we understand all people, as opposed to something else, then we're not going to get to a point where we're able to have a kind of solidarity or to have a kind of space even for working collectively in this way. And I think that's one of the reasons I really want to push the idea that the law is not the answer, that the notion of universal rights isn't the answer, because it is a system predicated on the notion that it's fine as long as you're within the nation state, as long as you're within the jurisdiction of the bounded nation state, as long as there is a higher state power that will recognize you as having that right, and therefore bestow upon you the material consequences of determining you to be human and having that right. And as we know, it's just simply not the way in which the world is structured. And that's why I want to move away a bit from the idea of universal rights as our kind of fallback or our ultimate call, because I think it really destroys collective struggle. I think that it means that it depends on the law imbuing you with rights, and then the law responding, or the state responding and recognizing, or a judiciary recognizing and responding that right. And so I'm not sure. It's not easy. But what I try to do at the end of the book is to try to think through what migrant solidarity might look like when it doesn't depend on the law. And I do think that things like education and changing minds and talking about migrants as people rather than migrants it seems like a small step, but I actually think it's quite radical in order to break the bounds that the law and the power that law has over us in how we make our demands. And I think it can allow us to make much broader demands. And for instance, I try to conceptualize irregularized migration as anti-colonial resistance. And I'm not saying that as like, oh, everybody should migrate irregularly, because that's, the be all and end all of expression of anti-colonial resistance. Of course not. Putting one's body in such a vulnerable position is not something that I would ever call upon. But what I would say is that if we can conceptualize irregularized migration as resistance, as anti-colonial resistance, we can begin to shift the ways in which we think about law and kind of take away some of its power in determining and defining life and ways of being and movement and entitlement. Because I think that's the problem, is I think that when people are imbued with rights and a sense that they that they are entitled to something, the other side of that coin is that there are people who aren't. And it is about moving away from, I think, from nationalism, about ideologies of nationalism, because it is precisely, law depends on the bounded nation state and a particular higher power that would then determines the application of the law and who falls within a jurisdiction, who falls without. And so again, that's what I'm trying to do with the book, is actually say Britain is not a bounded nation state. Britain is produced itself through law as such, but actually it is not that. It is something very different if we look at the way in which it was formed throughout history.
And I think... Sorry, I was just sorry for cutting you off, but that was really, really interesting. We could go on forever, but I think I want to get to some of the questions. You probably get time to respond in the questions, because the questions have also been related to universalism. We could probably start with those ones, actually. So there was a question about, to Dalia, what would universalist demands look like materially? What would these mean? And I guess maybe one of the questions that I could throw towards Nadine would be some alternative articulations in activism. What could our demands be? What are alternatives? What would this be an alternative to citizenship? Refutation of categorization at the national level? And there was also a question around the is there a way in which activists and scholars can work with legal practitioners to reframe these demands and to reframe legal challenges? I think there's enough here to maybe continue the discussion around perhaps internationalism and universalism along internationalist lines. I don't know, but you guys can take it from there.
Yeah, Dalia, you go first, because I just said
Yeah, I think this is like a really key point, and it's something that I've been really trying to work through, because there is this question of, the very same people the very same institutions that have laid the groundwork for the kinds of violence, of categorization that we are seeing, are the very same institutions that develop notions of universal human rights. And Nadine is completely correct to say that, through like legal maneuvers and through cultural work and through all these different kinds of mechanism, we are able to both hold this idea of the universal human right, but also this idea that the category of human is very much socially bounded, it cannot be taken for granted, and that the ways that nation states, etc., have gotten around that is to create conditionality to the access of the human, and then so that's very much, and I think that's completely in the history of the universal human rights notion. So I guess for me, like, the question is, how can we recognize that exclusion from the category of human means that the universal human right is able to stay intact alongside these forms of violence that deny people access to the category of human. So really the question is by ensuring how we can create notions of universality that are not based in and do not emerge through and alongside, and this idea that cannot exist alongside things like nation states. That we articulate that if this is the thing that we are holding up, that everyone has a right to shelter or whatever, to shelter, to family life, that cannot be achieved so long as these mechanisms of categorization, and be that the nation state, gender, etc., so long as those exist, they preclude us from accessing that idea. So I think for me, the question of universality comes into this idea of, you know, if we're talking about short-term policy, when we think about things like universal basic services, the idea that everyone can have access to something regardless, and those kind of artificial forms of boundary making are irrelevant. That is the kind of, you know, when we talk about universal basic services, there's always this idea of like, oh, well, you know, what about, does that include kind of like these people, and should it include these people, and should it include these people? Well, we need to get where we want to get to in our struggle, in our activism, is a question when it is a point where those questions cannot even be asked because they don't make sense. Does that make sense? So like, I think it's that it's, and I completely, like, those two things are completely held in tension for me. But I feel like there is something to be gained in how we can think through those in what framework can we use in order to think through those categories and those mechanisms of categorization in our activism. So, and that concept of universality, when thought outside of that idea of universality as distributed through the law and handed down by institutions, but actually in that kind of ground up way, is a way that we stop getting bogged down in questions of who gets to have the rights of the fruits of the things that we struggle for, in a sense. So I guess, like, I think recognizing that question of how the universal human right is not enough because not everyone is considered human, of how we push through that, and how we can have at the heart of our struggles this idea that those questions of who does and who does not have access to the fruits of our struggle is not a question that makes sense. That's where the point that we want to get to, if that makes sense.
Absolutely, it does. And I mean, I think that the problem is, particularly with anti-racism work, is that we're always on the defensive. We're always trying to protect ourselves, trying to protect the most vulnerable. We're constantly under attack from new policies, new horrific pieces of legislation, new brutal violences that occur every day. So what we're trying to do is react and respond with arguments that are sometimes actually come across quite utilitarian and are about protecting the particular group that are under attack right now, and everyone else gets pushed under the bus. And I think that what you're saying is really important. Your ideas around universalism are really important for making sure that when we're in that defensive mode, we're precisely not doing that, where people are getting pushed under the bus in the service of making a particular urgent political argument. And I think that's where the question comes in, which I think Isham was asking me about the connections between maybe legal practice and those people working within the system and those working outside. Because it's of course the kind of incremental improvements to the system, which are always going to be limited to particular groups, and maybe will have negative effects for groups that are not included in particular legal victories. They're so important for the individuals who are affected that I say very clearly in the book that work being done by legal practitioners is so important. But at the same time, we have to, as you are saying, keep another language sort of in our armor, and another way of seeing what is happening in our armor, and make sure that when we're making political arguments or sort of, and it's, of course, it's not, I was going to say from the position of a position of luxury, say of the latest blog piece on whatever latest attack on migrants has occurred. we have to be careful to imbibe exactly the kind of politics of universalism that you're talking about, and one which doesn't work on a sort of basis where a win for some is worth it, even if it's a loss for others. And you know, I'm going to come back to Windrush there, and the way in which the arguments were made around, well, this group, you know, are citizens, and they were citizens, so they should get these rights, when so many people who were not citizens, who did not have a regular status, were of course left by the wayside, and much worse, were of course subject to deportation and death as a result of those policies. So it is about, as you say, holding these two kind of positions at the same time, and it is very difficult to do, but it is crucial, I think. And one of the things I found and felt really I think lifted by is the response from legal practitioners to the book, because I worried that they might see this as too radical and too irrelevant, but actually they have the insight from working within the system about exactly the violence of it, the way in which it operates. And they have said it is such a relief to see a book that is so closely, that looks so closely at the law, but also kind of tries to push outside of its boundaries of categorization, and think more towards the way in which you're talking about a real what a real politics of solidarity would look like. And I think, you know, I end the book by thinking about how colonial legacies remain everywhere. That it's not as though colonialism is over and we're just tidying up its mess now. Actually, it's legacies of racism, it's legacies of inequality, of lack of access to the basic means of life are everywhere. And the British Empire was almost everywhere. And even if it wasn't in every single territory that we might see in a geographical sense today, its legacy of racism is in every corner of the world. And there is nowhere you can go where that legacy of racism has not touched. And so if you think about Britain in that way, i.e. not that bounded nation space, but actually as being everywhere all of the time, we are all one collective. We are all connected in that way, and everybody touched by Britain's legacy is equally entitled. I think in the way that you're talking about, it is equally entitled. But it is difficult to use the language of rights and the law when, of course, you see the way in which law, rights, and categorization are at the very heart of colonial practices, and indeed are embodied in law today. But I think that there's something there, and I think it is really important to think about the ways in which we can hold, as activists, as scholars, as thinkers, those two things at the same time. Yeah.
Okay, so I think there are just 2 or 3 more questions that I do want to go through, if that's okay with everyone. Some people are dropping off, but that's okay because we're going to record it, and then if they want to still have answers to their questions, they can watch that. Just wanted to say that it does, what you just said makes so much sense. I think it's really difficult to make sense of the world if you don't think of colonialism. Like Fiji's sugar production would make no sense if you don't think of colonialism, the economy of so many countries. So we have a question on categorization, which both of you touched on as of a lot of interest to you. The categorization of the economic migrant and the asylum seeker, the dichotomy between these two. And there was another related question on how can we move beyond categorization in the pursuit of universalism. And I'm going to add to this, how can we do this in a way that doesn't ignore the function that these categories play? How can we do this in a way that how can we move beyond race? How can we dismantle racism, basically, without ignoring race? I think, and just the last question, because after this we'll stop, was Dalius, the question for you and related to your work, about how precarious work and produces racialized violence, and perhaps also produces gendered and racialized violence.
Yeah, I think I've been. There's obviously like so many ways to talk about how do we go against these kinds of strategies. And I think for me there's these strategies of division and strategies of categories. And for me, I think I've learned so much of my thinking from prison abolitionism. Like that is like sort of where I think I learned the most about this, because and this again connects to Nadine's book, is this idea of when something becomes categorized as a crime and someone becomes categorized as a criminal, they become that's when they fall out of that category of human again, and they become and the violence that can be meted out to them is almost limitless. And I think that fighting the category of criminal and fighting the mechanisms of criminalization, and that's what the hostile environment did so effectively, was that it criminalized being able to work. It criminalized being able to move to where your family are. It criminalized being able to support your family, your community. It criminalized so many things that make someone inherently human. Therefore, in order to be law-abiding, you have to give up your status as human. And it's also that way that the fact that, when we look at detention centers and how these things operate as almost like just black holes of where unspeakable forms of violence can happen, it's because of that, the power of being categorized as criminal. And it is such a powerful and important part of racialization. And it is such a powerful and important, and austerity as well. I think that's something that we don't talk about as much when we talk about austerity, is how being poor, being homeless, being, poverty and homelessness, etc., again, became criminalized. And once you do that, you push someone out of the category of human, you deny them their ability to vote, you deny them their ability to form connections, to speak to their family members, etc. When you become incarcerated. That for me, and I think it's also the category that a lot of, particularly the more liberal migrants' rights organizations, those are the people that get thrown under the bus in the service of particular policy wins. So this idea of, and I think that's again how the criminal, how the kind of the power of criminalization and how effective it is. It sort of forces people to fight for the rights of particular groups and particular individuals on the basis that they're not one of those. So then the opposition of that is that if someone does become designated as a criminal, then anything can happen to them. So I think for me, that is really the category that is that, and the literature really that I'm learning so much from, and I think is kind of at the core, like it's almost the category that is positioned at the bottom of the heap. And it's a category of dehumanization that is accepted by so many people. People will not accept people are much more likely to be vocal against the abuse of, a minority healthcare worker, but the state can rouse up and can unify people in hatred of the racialized, quote unquote, criminal. And so long as the state has the power to criminalize in that way, that is their key way of of doing all of the things that we've talked about. So for me, learning those lessons from prison abolition literature has been really critical, I think, and is the foundation, I think, of a lot of my politics and a lot of my ideas of what should underpin a lot of our struggles as well. So I would really recommend sort of delving into that literature, because it's really at the core, I think, of what a lot of what we need to fight for.
Thanks, Dalia, for that. I think that's going to be really helpful to listeners, and I certainly agree that thinking about abolitionist literature is really helpful for trying to understand how racializing processes work, I suppose. And I think that kind of links on to Ishan's question about trying to move beyond or tackle, what was it? Tackle race? No, can you just
dismantle racism? How to dismantle racism? No, well, the question was to
without sort of ignoring or
yeah.
I mean, I think I suppose the reason I don't find that as difficult a question is because I'm interested in racializing processes, and that's why I'm so interested in law. Of course, one cannot ignore the material effects of race, and we understand those as racism. And we see that when people are made disproportionately vulnerable to harm and premature death through racializing processes, and I mean things like encounters with the border, being rejected from a particular legal category, being found not to meet a particular criteria, all of that produces a racial subject. And then that racial subject becomes vulnerable to harm, and that's where that links to the question I was asked about the difference between economic migrant and refugee, and that kind of distinction is that when you are left outside of a category, you then become subject to the risks which you are placed in the way of because you have been evicted from the protection of legal status. And of course, the refugee has a protected legal status. But of course, states find a lot of ways to offset that protection via immigration controls, border controls, methods of preventing people from being able to travel safely, all in the service of what? Of immigration control, of the right to protect one's sovereign borders from invasion, of the right to protect one's welfare state from being accessed by people who don't deserve that welfare state, of the right to ensure that council housing goes to people who deserve that council housing and not unjustly enriched migrants. And so what I try to do to tackle racism and that racializing process is to start from the false idea of the unjustly enriched migrant. And the only way you do that is to understand how Britain was made and to understand the racializing process of the very construction and production of Britain as a modern nation state. And then all those arguments that are made around the unjustly enriched migrant fall away when we really understand and can challenge and see Britain as an ongoing contested colonial space, something that is very rarely done. British colonialism ended. There are settler colonies where land remains contested, etc., but that's not something that affects Britain. So that's the kind of thing I've been trying to do, is really look at the racializing process and then its material effects in that way. But I'll stop there because I know we have to end. But I did put the discount code in the chat, but maybe Ishan, you could pull it out and just email it to people that yeah. I'm not trying to sell the book. I'm just trying to say.
No. I think everybody should read the book. If it was up to me, I would get everybody to read the book, but I don't think I can do that. Definitely think this was brilliant. Thank you so much, both of you, for speaking. I've learned a lot, and I just wish we could continue doing this forever. We will do more events, and then we will be able to continue these discussions. Some people asked some more questions in the chat, but unfortunately, we don't have enough time. Thank you for listening to the Race in Britain podcast.